The courtroom buzzed with an intensity that could only be described as electric. Judge William Adler pounded his gavel with authority, issuing a fine to the defense attorney, only to realize moments later that he had inadvertently penalized none other than the Vice President of the United States. A collective gasp swept the room as tension settled heavily in every heart. This high-stakes case had already drawn national attention, centering on Titan Digital, a multi-billion-dollar tech conglomerate accused of severe ethical violations ranging from mass data privacy breaches to deliberately manipulating market competition through underhanded tactics. Judge Adler, a man whose reputation for fairness was matched only by his intolerance for theatrics, adjusted his glasses as he scanned the packed courtroom. He had presided over enough high-profile cases to know when an attorney was out of his depth. Yet, the man before him, who had only just been introduced, carried himself with an unsettling level of confidence. No nervous tics, no fidgeting, just a calm, measured expression as he methodically straightened his suit jacket. When asked if he wished to respond before the witness testimony began, the defense attorney finally spoke. "Your Honor, my name is John Vance, and I intend to demonstrate that the prosecution's case, while seemingly compelling, is built on misinterpretations and selective framing of the law." Across the aisle, the prosecutor Linda Pruitt, a well-respected federal attorney known for her ruthless courtroom precision, rose like a shark sensing blood. "Your Honor," she declared, striding confidently to the center of the room, "the facts of this case are undeniable. Titan Digital knowingly engaged in unlawful data collection by harvesting personal information without consent and then profited by selling that data to third parties. They manipulated algorithms to suppress competitors and force small businesses out of the market. Internal memos reveal that senior executives were fully aware of these practices, yet they chose profit over ethical responsibility." Her words, sharp and incisive, drew murmurs from the gallery as the gravity of the accusations set in. Judge Adler's eyes flickered between the prosecution and the defense. He had seen many attorneys attempt to tilt the narrative in their favor, but John Vance's measured tone and quiet authority began to unsettle the room. "Counselor, before we proceed with witness testimony, do you wish to offer a response?" he inquired. Vance stood slowly, buttoning his suit with deliberate ease. "Your Honor," he began, his voice steady and controlled, "I will show that while Titan Digital's actions may be distasteful, they fall within the current legal framework. Intent and application of the law matter. The evidence the prosecution offers is based on selective interpretations that fail to account for the legal boundaries within which Titan Digital operated." A ripple of murmurs passed through the courtroom as Judge Adler called for the first witness. Special Agent Daniel Briggs, a tall, broad-shouldered officer in a crisp uniform, stepped up to the stand after taking his oath. "I oversee operations targeting high-priority deportation cases," he explained. "During a recent raid, our team encountered a suspect who refused to open his door. Instead, he was seen reading from a document, a step-by-step guide on how to avoid ICE, distributed by Representative Ocasio-Cortez's office." Agent Briggs's testimony sent shockwaves through the courtroom, prompting Bondi to lean toward the jury. "This is not an isolated incident," she asserted. "Since the defendant's materials began circulating, resistance during enforcement operations has measurably increased." During cross-examination, John Vance pressed, "Agent Briggs, in your 15 years of service, you're aware that the Fourth Amendment protects citizens from unlawful searches. Isn't that correct?" Briggs hesitated before replying, "Technically, yes." Vance continued, "And did your team have a judicial warrant to enter the residence?" Briggs, his jaw tightening, admitted, "No, it was an administrative order." Vance seized the moment. "So the individual exercised his legal right to refuse entry. That is not obstruction. It is the law." The courtroom buzzed as the next witness, Officer Daniel Reynolds, took the stand. Reynolds recounted a raid where protesters, inspired by public statements, blocked access to a residence. "We arrived and encountered a human blockade," he said. "People were reading aloud from a Know Your Rights pamphlet distributed by the defendant's office. By the time we intervened, the targets had vanished." When asked if these public messages had encouraged resistance, Reynolds replied firmly, yes. The vivid imagery painted by his testimony reinforced the prosecution's argument that the defendant's rhetoric had tangible, disruptive consequences. Yet, John Vance countered, the right to exercise constitutional freedoms is not a crime. If a company adheres to its legally disclosed practices, should we penalize it for exploiting every legal loophole, even if that exploitation is unethical? His words forced the jury to confront the uncomfortable truth. What is illegal, and what is merely ethically questionable behavior within a flawed legal framework? As the day progressed, Linda Pruitt summoned former Titan digital employee Sarah Levine, a woman in her early 40s who testified about her role in internal compliance. I reviewed company policies and witnessed emails where executives discussed adjusting procedures to avoid regulatory scrutiny. Levine whispered, her hands trembling as she recounted the internal culture of bending rules without overtly breaking them. When pressed on whether these practices were formally reported to federal authorities, she admitted, no, Vance used her testimony to drive home a crucial point. Titan Digital's actions, while morally dubious, did not explicitly breach any written law. The prosecution then called the cybersecurity analyst, whose detailed report on Titan Digital's algorithms revealed that the company designed its systems to favor its own products while suppressing competitors. These practices are common in the tech industry, the analyst noted, but Titan Digital took it further, manipulating user behavior in ways that push the boundaries of fairness. Vance, however, stressed that if such practices were disclosed in the user agreement, they might not constitute a legal violation at all. Judge Adler interjected at one point, warning Vance, this is not the time for philosophical debates on legality. Yet Vance's arguments resonated with some members of the jury, igniting murmurs of dissent among those who felt the law was too lenient. In a dramatic shift, the prosecution called CEO Robert Landry to the stand. Landry, the polished face of Titan Digital, maintained that the company had always operated within legal limits. However, when asked about internal warnings regarding ethically questionable practices, his discomfort was palpable, a slight twitch, a hesitation, suggesting that his firm's internal policies might not have been as transparent as he claimed. The climax came when John Vance produced a folder from his briefcase, a folder that contained official documentation verifying his identity and his temporary reinstatement as a practicing attorney. As Judge Adler flipped through the pages, his expression changed from stern authority to incredulous realization. A collective gasp filled the courtroom as it emerged that the defense attorney was, in fact, the sitting Vice President of the United States. The shock was palpable. Reporters, jurors, and even the prosecutor, Linda Pruitt, were momentarily frozen by this revelation. Judge Adler's voice, now strained, declared, Vice President, you should have disclosed your identity at the beginning of this trial. For procedural misconduct, I hereby fine you. Vance, now revealed as the Vice President, responded calmly, I accept the fine, as is my legal right. His measured response deepened the courtroom's astonishment as the layers of the case began to shift in unexpected ways. The remainder of the trial evolved into a profound debate on the limits of regulatory enforcement versus the sanctity of constitutional freedoms. Vance argued that if the law does not explicitly prohibit an action, penalizing it amounts to punishing adherence to the letter of the law. We are here not to punish unethical behavior per se, but to examine whether our legal framework is robust enough to hold companies accountable, he told the jury, his voice resonating with quiet authority. In his closing argument, the prosecution maintained Titan Digital knowingly exploited legal loopholes to engage in practices that harm consumers. Regardless of intent, obstruction of justice cannot be tolerated. In response, Vance's rebuttal was both impassioned and methodical. Ladies and gentlemen, he said, if the law is weak, then no amount of courtroom punishment will remedy its deficiencies. Instead of scapegoating a company for operating within legal boundaries, let us use this opportunity to reform the laws that allow such exploitation. After hours of deliberation, the jury finally returned with a verdict. Not guilty, on charges of corporate misconduct and unlawful data collection. The courtroom erupted in a cacophony of reactions, gasps, murmurs, and even a few cries of disbelief. Amid the chaos, Vance's quiet nod and Pruitt's stoic expression told a story of a battle that had been fought on both legal and ideological fronts. As the judge banged his gavel for the final time, declaring the court adjourned, the nation was left to wrestle with profound questions. Had justice been served, or had the law simply upheld its own limitations? Was Titan Digital merely a scapegoat for systemic issues in corporate regulation, or did its practices warrant a harsher response? And most importantly, what precedent would this trial set for future cases where unethical actions fall into a legal gray area? Outside the courtroom, media outlets swarmed, and social media erupted with hashtags and debates. The trial had become a referendum on the balance between ethical responsibility and legal technicality, a debate that resonated far beyond the corporate world. John Vance, now a figure of unexpected power and insight, gathered his papers with an air of quiet satisfaction. Even as the courtroom emptied, whispers of his performance and his hidden identity continued to ripple through the corridors of power. The legacy of this trial, marked by its twists and revelations, promised to reshape the discourse on corporate accountability, regulatory reform, and the interplay between law and ethics. As the news cycles churned and commentators dissected every word, one thing remained clear. In a system where legal loopholes can shield unethical behavior, the call for change has never been louder.